Okay, folks, welcome. This is the first videotaped lecture for the law of property and estates. And today I hope to be covering the first few handouts that are listed on Blackboard. And they would be the handout entitled Introduction to Real Estate Law, another one called Court Terminology, and then the last one will be the Bill of Rights, and also a handout that is just a quick outline of the Constitution. So today we're going to talk about some of the background information, just about how laws are made. We're going to go over some of the terminology to try and get everybody up to snuff. If you've had a constitutional law course previously, you've probably heard some of these things, but I like to make sure that everybody starts off the semester on the same plateau, on the same plane, with the same basic knowledge of how laws are created and where they come from. And my experience has been that you get very little of that in high school or junior high school anymore. So I have to presume that you guys come here not knowing a lot of it and have to get you up to speed, and then we can get into the specifics of property law and the law of trusts and estates. All right, that being the case, beginning with the handout called Introduction to the Law. Basic question: where does law come from? How does it originate? How does it get to be the law? And in our system, in the United States of America at this point in time, that question has a fairly complicated answer. Originally, the 13 colonies that eventually became the first 13 states under the constitutional government were colonies of England, of the British Empire. The vast majority of the Europeans who settled in them prior to the Revolutionary War and prior to the adoption of the Constitution were English citizens, and they did not in those days worry about cultural appropriation or worrying about how minorities felt. When the British came to North America, they did not say to the indigenous peoples, to the native peoples, oh, show us all your laws, tell us your ways so we can fit in, so we can assimilate. They came with their law books, they came with their Bibles, and they basically said, what we were doing in England, we are now going to do here. And it was a very long period of time. The English first made a permanent settlement in what is now the United States in 1607. Followed a few years later in 1620 by the Pilgrims down the road in Plymouth. And they basically continued living under the British system from that point in time for well over 150 years, up into the 1770s when the revolution against England began. And even when the revolution took place and the British rule was ended and the states became independent, one of the interesting things about the American Revolution is that it is not a cultural revolution. It was not particularly an economic revolution. It was basically a revolution saying we don't want the King of England to be our ruler anymore. We don't want to have to listen to the British Parliament making laws for us. But in almost all other respects, they kept the attributes of British law, they kept the attributes of British society and customs and the British economic system to a great extent, so that there was not a tremendous change for the average person when their state, Rhode Island or Massachusetts or Virginia or Georgia, went from being a colony to being independent and then becoming part of the United States. They did not see a real change in the day-to-day way that the law was applied, how it operated in their lives, and that was particularly true for the law of property and even to a great extent for the laws of inheritance, the laws of estates and trusts and wills. So, having said that, we have to back up a little bit and say, all right, where did the British law come from? How did the English deal with creating laws and running their legal system? And in order to understand that, we have to look at two very different ways that laws became laws in England. First way, and probably for a good part of British history, the most important way that laws became law was through something called the common law. And the common law was basically a compiling of 1,000 years of legal decisions made by the king's courts and then brought together into a type of systematic program where the judges would read each other's decisions, they'd read the decisions of the judges that came before them, and out of this developed theories of law, and particularly when we're dealing with real estate law. As we get into some of the aspects of real estate law, they're going to seem very strange and very alien and not at all suited to the 21st century. And there's good reason for that, because some of these rules originated in the 12 and 13 and 1400s and have been carried down through the British system to the colonies and to us today, and have not been greatly changed. Now, one of the things that made the common law what it is a concept called precedent, or stare decisis, or in its modern American term, we call it case law. The British judges, when they were first appointed by the kings to go out and to hand out justice to folks, there were not a lot of rules. The kings were not really interested in laying down a lot of laws. As long as they got their taxes and the countryside was peaceable, they really didn't care an awful lot about what was going on. The judges were pretty much free to make decisions as they saw fit. But one of the things that they quickly realized is that they had to be consistent in their decisions. They could not flip-flop back and forth, so that if a person's geese were killed by a knight riding by on a horse one year, and the judge said, knight, you killed this woman's geese, you have to pay her. When the same thing happened to another person a year later, the judges could not say, oh, no, you don't get compensated. We don't care about you. We're not, this person who killed your geese doesn't have to pay for them. The people very much were attuned to what was going on in the local courts. Remember, there was no TV, no radio, no theaters. When the judges came into town to hold court, basically everything stopped and people watched and listened. And the idea of the law must be consistent very early on came into the British way of doing things. And one of the things that was also very important is that going back almost 1,000 years, the British courts wrote down their decisions so that a history of cases and how they were decided, what the facts were, what the decision was, began to build up. And of course, legal scholars and professors would start analyzing them and digging into them and coming up with a series of rules that developed. So you have this idea of the court system developing its own set of laws based on precedent, based on the idea that once we've decided that a certain situation should be handled this way, that's what we're going to do in the future. Great benefit to people to know what a decision is going to be, to know what the law is going to be. Great benefit to lawyers. When they bring a case, they can look back at the old decisions and they can rely upon them, and they can use them to argue, to say, Your Honor, my client should win, because if you look at these 3 previous cases in the last 50 years, judges faced situations similar or the same as my client's and ruled in my client's favor in those cases. So it became a very important part of the structure of English law. And it continues to be important today in American law. We'll talk about that a little bit further on, but the whole idea of precedent has become extremely important in the American system of courts and of legal law creation at this point in time. Now, very quickly, the courts evolved a system where there are basically 2 sets of laws running parallel in the court system at the same time. And one of the things that lawyers do is that we're constantly classifying things, so that we're looking at a situation, we're trying to break it down to its component parts, and we try to classify the law so that we can say, all right, this law fits in this part of the case, this law fits in that part. So if you study the law with any thought of trying to understand what's going on behind it, you realize that we're constantly creating these classifications. We'll have a set of things, then we break it down to a subset, then we break the subsets down to a subset, always trying to get the law to apply exactly to the situation that we have in front of us. The first great classification in the legal system as a whole in both England and the United States is we break it down between criminal law and civil law. Now, criminal law, the law of crimes, are rules that have to do with offenses against the state, in addition to being offenses against individual victims. So when you murder someone, when you kill another human being with malice aforethought and cold blood, you're not only injuring that victim, but that's an act that is so outrageous, so contrary to the norms of society, you're also acting against the state. And as such, even going back into almost medieval times in England, there would be prosecutors who would handle these charges, bring charges for the state against a person, would prosecute, bring the case against the person. And of course, the whole issue in a criminal case is to determine, did the person do what they're claimed to have done? If they did it, does it constitute a crime? And of course, if it constitutes a crime, the criminal law, going again back to 1,000 years into the Middle Ages, gives the judges the power to punish, to impose prison terms, death penalty, fines. So that's one aspect of law. The other aspect is the civil law. And basically, the civil law is a recognition that one of the principal jobs of the court is to hear disputes between private parties, between two citizens, between two people, and to come to a resolution of that dispute if they cannot resolve it themselves. What we're going to be studying this semester, 99.999% of it falls under the civil law, under the civil jurisdiction of the courts, and is a very important thing. And again, even today in the United States, criminal convictions in the criminal court system is very large and very important, but the vast majority of cases, and I would say the vast majority of the court's time, is taken up handling civil matters where you have individuals suing each other, individuals who are engaged in a dispute, bringing their matters to the court for the court to make a decision. And at the bottom of it, when you look at the English system of courts and how they've evolved and what they mean, every situation in court is an argument. It is a dispute. You have one side saying this should happen. You have the other side saying, no, we don't think that should happen. Something else should happen. One side saying, I'm right. The other side saying, no, Your Honor, I'm right. Even in a criminal case, there is a dispute. The dispute is saying, oh, you, Mr. Defendant or Miss Defendant, did this horrible thing that we should be able to put you in jail for. And on the other side, you have the defendant saying, either, no, I did not do it, or there were mitigating circumstances, so I shouldn't go to jail for doing it. So even in criminal cases, at their essence, at their nature, are disputes. And the whole purpose of the court system is to resolve these disputes when the parties are incapable of coming to some agreement between themselves. Now, the English courts evolved with two systems. And it's kind of difficult for modern people to understand. And the American system has done a very good job of merging these things so that only lawyers and very often only litigation counsel even understand them anymore, even pay much attention to them. But in England, there were the king's courts. These were the civil courts. These were the courts of law. They handled, again, criminal cases. They handled most types of disputes. However, the secondary authority in England and in most of Europe in the Middle Ages was the church. And the church had its own set of courts. So if you were a priest, if you were a nun, if you were involved in some kind of an argument against the church, you had to go through the church courts. You could not go through the king's courts. They were held to have no jurisdiction over religious matters. And of course, the church in the Middle Ages was very powerful. It was a landowner. It ran businesses besides having the what we think of today as religious activities of holding services or maybe running hospitals or institutes for the poor or whatever. The church did all of that, but they were also involved in commerce. They were involved in landowning. They were involved in settling disputes between family members. So for many years, for several hundred years, you had these two court systems running parallel to each other. In the law courts, the ideal was that we have a law, we have a rule, and the judges must apply it, and there's no variation from it. Whatever the rule says has to happen, which is how the British system got into some unenviable situations, such as executing people for stealing loaves of bread. If the law at the time said that, the judges had no power, they felt, to mitigate or to listen to extenuating circumstances. They had to apply the letter of the law as it was written, regardless of emotions, feelings, justice, circumstances. The church law, coming out of a Christian background, was quite different. In the church law, you could argue motives, you could argue circumstances, you could argue mitigation. And this whole system of being able to kind of work around the letter of the law came to be called equity. The idea of, well, what makes this equal? What makes it fair? What makes it just? Not just, did the technical law get violated or not? Both these courts were separate until Henry VIII came along in the 1500s, and because of his problems not being able to have a son with several different wives and his issues that brought between him and the popes, Henry, of course, removed the Catholic Church and the power of the Pope from any control in England, established the Anglican Church, and as part of that took over the church courts and merged them with the King's courts. However, for many years, right up into the early years of the American Republic, there were still two separate courtrooms. So you could argue your case on the legal merits in one court, and if you lost there, you could then bring the case the next day down the hall in the Court of Equity, and now equitable rules would apply, and hopefully somehow this judge would say, oh no, there were mitigating circumstances, that's not really fair, we can amend the legal decision. So both of those systems existed in the 20th century as particularly the federal system began to reform to try and bring the courts into the 20th century and into the modern times. We now have merged law and equity so that it's only one court system. There are no such thing as equity courts in the federal system and certainly in most states at this point. However, when a lawyer brings a lawsuit, you still have to look at both sets of rules, and you will very often plead your case in the alternative, meaning first you'll say, well, Your Honor, here's all the legal rules. Here's all the legal reasons which if you apply them to our facts, this is why my client should win. And however, Your Honor, if you don't think that's enough, here are the equitable rules. Here's how they apply to our client. And if you don't think we have enough to win the case on law, then please look at the fairness, look at the justice, look at the mitigating circumstances here, and give the case to our client. So the two systems of law have not really disappeared, but we've just kind of, for efficiency's sake in the modern world, we've put them together so that in any given lawsuit, very often both of sides of that are being argued. Now, so one major way that laws were made in England was by the court system, through precedent, through the idea of stare decisis, which is a Latin term meaning by the old decisions. The courts created a body of rules, a body of law that they felt had to be followed. Once they were put in place, subsequent judges and subsequent cases would have to follow the rules that existed. The other source of law in England was, and still is, Parliament. Parliament is a representative body of the English people. It is the equivalent of our Congress. There are two houses in Parliament. There's a House of Commons, which members are elected by the British population, by the British citizens, and there are the House of Lords. To become a lord, you have to basically inherit the title from a parent who was a lord before you, or you can be knighted and you can be made a lord by the present monarch. And if you are made a lord, that entitles you to sit in the House of Lords. But over time, and particularly in the last couple of hundred years, things have developed where the House of Commons really controls what goes on in the British legal system, and they are seen as having pretty much the exclusive authority to make laws with very little interference from the courts or from the House of Lords. Now, in Parliament, a law becomes a law because somebody introduces a bill saying, I have this idea. I think we need to lower the speed limit of driving to 50 miles an hour. I suppose in England it'd be 60 kilometers an hour. And we think this is a good thing and we should impose this rule across the country. The representatives would argue it, they would discuss it, they would take a vote on it. And if it was voted in by a majority, then it would become a law. Now, once that bill becomes a law, in our system, now in the United States, it's called a statute. All states have legislatures that have the power to pass statutes, and in the federal government, the Congress, the Senate, and the House of Representatives together have the power to pass laws and create statutes. Once a bill is enacted, is voted upon, and becomes a law. Now, in the federal system, one interesting thing that they added when they wrote the Constitution was that the president has the power to veto any bill before it becomes a statute. So when Congress, House, and the Senate pass a law, and most laws only need a bare majority to be passed, if they agree on each side, they have, by majority, they pass a bill into law. It then goes to the president. The president has the power to approve it, sign it, at which point it immediately becomes a statute and becomes law. Or the president also has the power to veto it, at which point it's dead. However, Congress can take up the matter again, and if they vote it through again with what's called a supermajority, 2/3 vote in each house, then it becomes a law without the president's approval. In our system, basically Congress makes the statutes, but the president does have a role given to him or her under the Constitution. In the United States, in addition to having the courts make decisions, which our courts still do, particularly appellate courts of the state, federal government, and the Supreme Court, when they hand down decisions, they're deemed to be precedent. Stare decisis applies so that subsequent decisions must follow that same ruling, and the lower courts are obligated to follow that ruling. But we added another layer to this because we have something the British do not have. We have a formalized written constitution. The Constitution was created in 1787. It was drafted. 1788, it was ratified by the 9 states required to bring it into effect. And its basic purpose was to create a government for the colonies that had now become independent from Great Britain. Basically, when the Revolutionary War was over, the British troops got on their boats and went back to England. You had 13 independent colonies sitting along the coast of North America, the Atlantic coast of North America, each of which was its own separate little country. Rhode Island printed its own money. Think of that. It became quickly apparent that that was not a feasible system, that the states would start fighting among themselves, and there was still the British, the French, and the Spanish Empire fleets floating around the Atlantic looking to take over whatever territories were weak enough for them to take over. So there was both the thought of internal squabbling and fighting and conflict, along with the idea of external enemies and problems. So particularly the wealthy class, the merchant class of people realized that they were still in great jeopardy, even though they had gotten rid of the British with the help of the French fleet. However, they realized that that could be very short-lived unless somehow they were able to get these 13 independent countries to work together. They first enacted a government called the Articles of Confederation. It was very awkward. It did not have great powers to make laws. For many decisions, it required not a majority, but a unanimous vote so that little Rhode Island could stop the other 12 states from doing something or from proposing something and making it a law. It had little power to tax. It could ask the state legislatures for money, but it didn't have any power to raise taxes on its own. And it really didn't work very well. So The states sent delegates to a convention in Philadelphia. The delegates came up with what is now our Constitution. The Constitution was enacted to create a government for the 13 colonies that would not do away with the states, not do away with the individual state governments, but would act as a super government to handle certain things such as the military and foreign affairs and other things that will affect us when we talk about property. Having done that, the states were very much concerned, and the citizens were very much concerned, that this new government could become as repressive or as difficult to deal with as the old British monarchy had been. And so, as part of the deal where states were agreeing to adopt the Constitution, there was an agreement made where as soon as it was adopted, one of the first things that would happen is that the new Congress would propose a Bill of Rights, and that would be enacted and would be drafted onto and attached to the new Constitution. And sure enough, it came to pass that the first 10 amendments of the Constitution were proposed by Congress and were enacted very quickly after the original Constitution was adopted. And for those of us today, when we think of the Constitution, very often we think about First Amendment freedom of speech, or Second Amendment right to bear arms, or right to privacy, and the abortion cases, Roe v. Wade. All of those things come to us not by the main body of the Constitution, which really spends a large portion, most of its wording, on setting up the new government and defining what the powers of that government will be. It's in the Bill of Rights that our rights are, as citizens of this government, are laid out and stated. Okay, an important distinction. Now, in the Constitution, and there's a chart that I have, it's handout 1. I urge all of you to look at it. You should not get past wherever you are in your legal careers or your educational careers without understanding how the Constitution set up this new government. The drafters of the government were concerned about uncontrolled power. Again, they had just freed themselves from a monarchy that was extremely powerful still, and from a parliament that was in control of everything the monarchy wasn't in control of, with very little power in the people to control either of those folks or those bodies. And so one of the great things they wanted to do was to make sure that nobody would have that power. They divided the government into 3 branches to spread that power out. They created a Congress made up of the Senate and the House of Representatives. They created the executive, which is basically the presidency, and then they created a judicial branch, each of them to be equal, each of them have their own sphere of affairs, and each of them to act as a certain check and balance on what the other branches of government could do. The president is in charge of the military. However, to get the funds to operate the military, he must go to Congress. Only Congress can approve funds and appropriate money. Congress can make laws. However, the president must agree to them, and he can veto them if he doesn't like them. Early on, the Supreme Court was called upon to see if certain things were legal and if they were, in quotes, constitutional. They didn't use that term at the time. In a very early case called Marbury versus Madison, the Supreme Court was basically asked to rule upon whether the actions of the executive branch were proper or not. And in order to do that, they had to interpret a statute or some statutes that had been written by Congress. In that very early case, the first Chief Justice was a very smart, very astute man. They ruled on the case, but as part of the decision, they put in language basically saying, some people would think we don't have the right to tell the executive what to do, or we don't have the right to tell the Congress what to do. We're just the court. We're just here to hear cases. However, there will always be situations where actions of the executive or laws passed by Congress need to be interpreted, need to be applied, where it needs to be determined if they fit within the rules established under the Constitution or not, and who is it that does that. who exists to interpret the law. That's the purpose of courts. That has been the purpose of courts since they were set up 1,000 years ago in England. So therefore, even though the Constitution doesn't explicitly say this, the court very early on took to itself the power to interpret the Constitution and to tell the other two branches of government whether what they were doing meets constitutional requirements or doesn't meet those requirements. And of course, once this case was handed down, precedent says this becomes the rule for all other cases. So for the last 230 years, the Supreme Court has basically been acting as the final arbiter of what the Constitution means and what the Congress and what the executive branch, the president, can do or cannot do within the framework of the original Constitution and under the Bill of Rights. Today, we'll talk about in a little bit how it came to be, but today they apply that same logic to the states by way of what happened after the Civil War. So basically it has come down to us now that the Supreme Court of the United States has a very powerful position, probably way more powerful than the framers of the Constitution thought it would have, because it becomes the final arbiter of what is allowed and what is not allowed under the Constitution. And we do not participate in the World Court. We do not participate in the United Nations courts, so that when within the United States legal system, once the Supreme Court has ruled on something, that's the end of the story. They are the highest authority. That becomes precedent for the entire rest of the system. The state courts, the lower federal courts, the Congress, the state legislatures, the governors, the president, all are bound by that decision. And basically, if they're interpreting a statute, then Congress or the state could always go and amend the statute. But if they're actually applying a fundamental right, if they're saying, nope, doing this, Mr. President, you're violating somebody's fundamental rights, the only way to change that type of decision would be to amend the Constitution itself, which is a very long and difficult process. It's only been done 20-some times in the 200 years because it is not a simple process to do, and unless you have almost unanimous agreement that it needs to be amended, it's very nearly impossible to get it done. So the Supreme Court has a tremendous deal of power at this point in time. Now, the Bill of Rights, first 10 amendments to the Constitution, set up the rights that we all think of, that we know. For many years, those only applied against the federal government, not against the states. Civil War came along. 1860, President Abraham Lincoln was elected President of the United States. He was a Republican. The Republican Party in those days was the anti-slavery party. The Democrats were the pro-slavery party. Think of that. Let that sink in for a bit. A few years before 1860, the United States had been in a war with the Republic of Mexico, and the result of that war was a huge piece of land between Texas and the Pacific Ocean that had formerly been part of Mexico now became part of the United States. So everything we think of, New Mexico, Arizona, Nevada, Colorado, California, all now were part of territory of the United States and were very quickly being settled. And under the system set up by the original Constitution, they recognized that the country would probably grow and take over more space on the continent. And they created a mechanism for territories to apply to become states. This had gone on from the 1780s right up into the 1920s, 1820s and 30s and 40s. And what had happened very early on was that a division began to arise between states that had abolished slavery or never had slavery and states that maintained the slavery system. You've probably all heard at this point about the 1619 Project, a rewriting of our history, emphasizing what had happened with slavery in the United States in 1619. The first slaves were brought to Virginia by some question as to what country it was from, but by a shipping captain who was unable to sell these slaves in the Caribbean. So he came up to Virginia, and that began the system of black African slavery within the southern states, and even to a certain extent there were slaves in the northern states, but very early on in the North, before the Revolution, the majority of the northern states had abolished slavery of any type, had created equal rights for all citizens. The southern states, as they were joining this constitutional government, they were actually in the process of increasing slavery, of pushing westward, settling places that would become Alabama and Mississippi, Kentucky, Tennessee, and bringing the slave system west with them. For many years, there was something called a balance where one free state would be allowed to come into the country and one slave state would come in to keep this equal, because the Southerners realized if they ever became a minority number of states, that Congress could vote to make slavery illegal at that point, and their system would be destroyed. And of course, particularly the southern plantation owners and business people, did not want that. They wanted slavery to be maintained. They saw it as the only way to keep their particular economy and way of life going. The Republicans in the 1850s developed a new political party, and one of the basic platforms of their party was that no further extension of slavery. They did not go so far as to say we need to abolish slavery here and now. They realized that they could not legally force southern states to do that, and there was some question as to whether even militarily they would be able to have enough power to force the southern states to do that. But they at least wanted to prevent slavery from spreading any further. And Abraham Lincoln's campaign slogan during the 1960 election was "not one more inch," meaning that they would not give another inch of federal territory to slavery. Now, this would end what had been a compromise for 50 or 60 years, because no new slave states would thus ever be admitted. And eventually, as the states going west across the country would be created and come into the Union, the slave states would be voted out, and slavery would disappear by legal process. And they knew that. So when Abraham Lincoln was sworn in as president, beginning with South Carolina, the slave states that became the Confederate states in the Civil War, one by one, voted to secede from the Union, to basically say that, well, this has been fine, this has been good, but we're going in different directions now. So you northern states have your country, and you can call yourselves the United States. You can continue to do that. We're going to leave the Union and create something called the Confederate States. And in our state, slavery will remain legal. Abraham Lincoln, and there's great debate going on now about Abraham Lincoln and what he stood for and did not stand for. He did stand for the proposition that slavery was abhorrent and should not be spread any further. And when the southern states attempted to leave the Union, he went one step further and said, no, that was an impossibility, that was a legal non-reality, that once a state had submitted to the Union, they were part and parcel, part of the United States of America. They did not have the power or the authority to leave at that point. And it was that particular issue that began the war, not so much the issue of slavery, although by the end of the war, ending slavery had become one of the primary focuses. But initially, the focus of Abraham Lincoln was to maintain the southern states, to keep them part of the Union. One of the ways he did that was he refused to turn over any federal army forts, army posts. He refused to turn over any naval bases or naval ships to the southern states. And of course, you ended up with a situation in South Carolina where Fort Sumter was sitting out on an island, Charleston Harbor, still controlled by the federal militias, with federal northern troops in the garrison and controlling the fort and the cannons that were aimed out at sea to keep invaders from coming in, but could easily be turned to be aimed at the city. The governor of South Carolina couldn't abide by that, sent his boys over to try and take the fort from the Federals, and the fighting began. 4 years later, somewhere between 600,000 and 800,000 dead. The war was resolved by the Union armies crushing the military of the South, forcing finally General Robert E. Lee, who was head of the Army of Virginia, to surrender to the Union forces. And the southern states basically became, for a while, conquered territories of the northern states. As part of that, as part of the ending of the war, and it wasn't immediate, it took a few years, but Congress, which was now still basically controlled by the northern states who had remained in the Union, wanted to make sure that legally we set up a framework where this can never happen again. And so they did several things. They passed 3 amendments to the Constitution, which we call the Civil War Amendments. First one, most important one, 13th Amendment, says that slavery is forever abolished, shall never exist ever again in any form, way, shape, manner, within any state of the United States or any territory that it comes to control, any possession that it comes to have, that slavery is not recognized as any kind of legal reality and is prohibited and forbidden within the United States. So thereby ending, mitigating, removing the first thing that brought about the war. The 14th Amendment, and let's jump ahead. The 15th Amendment gave all citizens the right to vote. And this was an attempt to give the vote, to give the franchise to the newly freed blacks that were now no longer slaves within the South. Now, having said that, in the 1860s, you must remember that women couldn't vote. You had to be 21. In many states, you had to be a property owner. You had to be a citizen for sure, and sometimes you had to have been a born here citizen. Naturalized citizens weren't allowed to vote. So the vote certainly wasn't given to everybody, but we're at least attempting to extend it from just white males to include black males who had now been freed and were now free citizens within the newly constituted southern states. Needless to say, the 15th Amendment took over 100 years to be effectively put into place. It was only the 1860s with the Civil Rights Revolution and Martin Luther King and the many of his followers and folks that came to reignite these issues again at that point in time that the 15th Amendment was ever fulfilled. 14th Amendment said a couple of things. First and foremost, it said that every citizen of a state is first and foremost a citizen of the United States. That had never been clear under the old Constitution. There was no way to really know if you said to somebody, if somebody was traveling in Europe, an American was traveling in Europe, and you said to them, where are you from? They would not usually say, I'm an American. They would have said, I'm a Virginian, I'm a Massachusettsite, I'm a Georgian, I'm a Carolinian. People did not really look at their citizenship as coming from the federal government, but from their individual states. Now the 14th Amendment is saying, no, you're first and foremost a citizen of the United States. Then it goes on to say that no state can deny equal protection or due process to any citizen of the United States. So for the first time, we have this idea that the Constitution might actually not just operate in terms of controlling the federal government, but might actually be a wedge where if I, as a Rhode Islander, feel that the governor or the legislature of Rhode Island is violating my rights, I can now turn to the federal government and say, they're violating my rights as an American citizen. They can't do that. Please stop them. That began to open up, at least theoretically, the whole civil rights movement that we've seen develop. But again, the Supreme Court was not terribly interested in dealing with this in the 1870s, 80s, and 90s. It was only when you got into the 20th century, and even then when you got into you had to go almost to the middle of the 20th century before the Supreme Court finally woke up and said, oh, Yes, this is important. We can do things like stop segregated education. Yes, we can do things like develop a right to privacy and impose it on the states. But today, the 14th Amendment is one of the tremendous protections that we have. Now, equal protection of law, guaranteed by the 14th Amendment, means that every citizen, every person should be treated equally under the law, that their race, their sex, their belief system should not affect how the law treats them. Due process of law means that there must be a system. There must be courts. There must be a way for you to bring your grievances to be heard, for a decision to be made. And as part of that, if you're suing somebody, they have the right to notice, they have the right to attend the hearings and be heard. So due process is the idea that we must have some system to address the issues and the grievances of the citizens. Equal protection says that within that system, all of them are supposed to be treated equally. Okay, I'm going to stop here. That ends the first handout. We will be back with more material.